As night follows day, some people in their police interview will always exercise the right to silence, give a no comment interview, or just remain silent to any police questions put to them by the interviewing officer. This might be for a number of reasons, but here's 3 why some people always give a no comment interview and remain silent. 1. A belief that anything they say during the police interview will be totally ignored by the interviewing officer. 2. They may feel the interviewing officer are not honest investigators searching for the truth in the police interview, but are out to get them, to get an admission or a confession to the crime, and they have previous negative experiences of this. And yes, many innocent people do have negative police lived experiences, just as many have positive police experiences. And 3. People who always give a no comment interview may believe the interviewing officer has already made up their mind before the police interview and is just going to charge them, and the police interview is just a tick box exercise. It's understandable why some suspects give a no comment interview or remain silent during a police interview, and some of these and other reasons may be the basis for good reasons why an adverse inference from the suspect's silence should not be made, especially if the police have made up their mind to charge you or the person or the suspect and take them to court. Please also watch How to Give a No Comment Interview and the 5 police tactics used to try and get you to talk, the 7 good reasons to give a no comment interview, and how to prevent a court interpreting my no comment interview as a sign of guilt. And don't forget to subscribe to Community Legal Education. But sometimes exercising one's right to silence might not be a good idea, might not be the best strategy during the police interview, and might not be advised by your lawyer. So here's 4 good reasons to talk to the police and to answer questions during a police interview. 1. By answering police questions, denying the offence and putting your defence forward at the first available opportunity, you're trying to persuade the police to take no further action. By looking the interviewing officer in their eyes, giving a really compelling and credible account, especially if you have the proofs, might lead to no charge, no court appearance, no headache of a court hearing to think about in the future, chapter closed, no further police action. Take the example of an allegation that is made that you have controlled and coerced your ex-partner, a criminal offence, by preventing them from leaving the family home you once shared together and preventing your ex from having a bank account. Can be easily refuted at the police interview with proofs that your ex had in fact a bank account and regularly met their friends by showing the police your ex's bank statements and photographs from Facebook of your ex with their friends. 2. There may be other benefits of answering police questions at the police interview and putting your defence forward at the first available opportunity, and this is to prevent any adverse inference from your silence being drawn if your case is likely to lead to a trial in several months' time. Let me explain this one. Here, answering questions verbally or by handing a statement in the interview, which is controlling what is put forward as your defence to the allegation, may be needed to support any claim made at a future trial that you haven't made up your defence between your police interview and trial, and so your defence at trial, that's the evidence you give during the trial, is strengthened because it's consistent with what you said at police interview all those months ago, and hopefully it's considered honest, credible and clear, and crucially not made to fit the prosecution evidence by any jury. Take this as an example. Imagine at police interview you're arrested for a burglary, placing you at the scene based on the sole witness ID testimony of one person, but you absolutely deny any involvement in the burglary, saying to your lawyer the witness is mistaken. If you say nothing to the interviewing officers during a police interview that you were not present and involved in the burglary, your no comment interview is likely to be interpreted by the police that you were in fact involved in the burglary because you haven't denied your involvement because you've remained silent. Therefore, you putting forward your defence of lack of presence when the burglary took place, making it absolutely clear that whatever the evidence the police might have, be it ID testimony or CCTV or other witnesses, you were not there when the burglary took place. You were not involved in the burglary. And that point of lack of presence put forward at the police interview is the pillar of your defence, which you would expand upon when you give evidence to explain where you were at the time of the burglary if the case went to trial, and more. By answering questions at the police interview gives you a much stronger chance of being believed by a jury than if you didn't make that point in the police interview. Or think about this as an example. An allegation that following a search warrant on your partner's home, unknown to you because you were staying overnight at your partner's home, a bag stashed full of drugs was found behind the kitchen sink. In this case, the strategy might be for you to deny at police interview you had absolutely no idea that there were any drugs in the property, and the bag full of drugs would definitely not have your fingerprints on it. And so, if the case does go to trial, at least you can say, I put forward my defence that I haven't been involved in storing drugs and have given a consistent account from my arrest to trial, that I haven't made up my story. Answering questions is not just about strengthening the chance of being believed at a future trial, but also that no adverse inferences should be drawn from your silence and no comment interview. 3. Sometimes answering questions at the police interview and admitting to the offence you're arrested for can lead to a lower sentence. It's a well-known sentencing principle that genuine remorse can, and in most cases, lead to a lower sentence. The idea of an admission at the police interview is to accept guilt, and in doing so show remorse at the earliest opportunity, which is at the police interview. Take this as an example. Following a police chase, you crash your car into a wall and you're arrested for dangerous driving and criminal damage. The evidence against you is not just overwhelming, it's an open and shut case. The offence of driving dangerously and criminal damage has been made out with the police car camera footage of the chase, police witness statements that you were the driver, and pictures of the damage to the wall. The only issue is how long you're going to get, prison or community order. The issue then is at police interview, do you answer questions or not? And what might be going through your mind is, what do you have to lose by answering questions? Or put it another way, what have you got to gain by answering questions? Admitting you were the driver, accepting you drove you over the speed limit, explaining that on reflection you know what an idiot you were for not stopping for the police, detailing that you now know the consequences of your bad driving to fellow pedestrians, passengers and road users, and explaining on record at the police interview that you have let yourself down, your family down, and you feel deeply, deeply ashamed of your behaviour. Think about it. All these points can be made by the advocate at sentence, that you accepted guilt right from the beginning at the police interview. This strategy of talking to the police at the police interview, admitting the offence early, may make the difference between a prison sentence or a community order, or a shorter prison sentence. 4. Sometimes by answering police questions at interview, by admitting the offence or some wrongdoing, can lead to a caution or a resolution rather than a court case and a criminal conviction. When it comes to cautions, they're issued after a police interview for low-level offences, where the suspect admits the offence and says they're sorry. They are still on the police record and may affect employment or obtain entry into some countries, but they are not a criminal conviction. As for local resolutions, if one is offered by the police, they're even better. An admission of wrongdoing at the police interview leads to no police record of a caution or conviction if the case went to court. Take this as an example. A neighbour dispute over parking, and you get arrested because you grabbed the shirt collar of your neighbour. That's an assault using unlawful force. Now you tell your lawyer that you admitted to losing your temper. It's your car parking space and your neighbour was being and it rhymes with custard. And your lawyer tells you the police have a statement from the neighbour and other witnesses that you lost your temper and you grabbed the neighbour's collar. And here's the other crucial point. The police officer lets your lawyer know this. If your client admits to the offence of assault, we won't charge, but we will arrange a local resolution to resolve the issue. That's a meeting with your neighbour. Would you not want to answer police questions in the police interview in this scenario? And if you remain silent, your case would likely go to court and lead to a criminal conviction. Remember, each case is fact specific and every police interview is different. So always speak to your lawyer before you decide in your case to answer questions or not. Thank you for watching. Please watch the other videos in the police interview series. Please feel free to comment and like this video. Don't forget to subscribe to Community Legal Education to be the first to watch our groundbreaking videos, and may the justice be with you.